at Venable, and I'll be your moderator for today's webinar on Opportunity Zones. Opportunity Zones are an exciting new community development program established by Congress in the Tax Cuts and Jobs Act of 2017. The goal of the program is to encourage long-term investments in low-income communities. As a coincidence of timing and a demonstration of the excitement about the program, the President is holding an event at the White House today regarding Opportunity Zones and is expected to sign an executive order today related thereto. Before we begin, I wanted to cover a few housekeeping items. At the bottom of your screen are multiple application widgets you can use. If you have questions during the webinar, you can submit them through the Q&A widget. We will try to answer the questions during the webinar. If we run out of time, we will follow up with you on any unanswered questions via email. Today's program will be recorded. The recording and corresponding PowerPoint slides will be available for download later this week. We will also send to you these items via email later this week. 1.5 CLE credits are available for this program. We will send to you a CLE request form via email as well. Please stand by until the end of the program to receive the CLE code. Venable is an Am Law 100 firm with more than 100 years of history. Venable has approximately 700 lawyers and offices in Washington, D.C., New York, Baltimore, Los Angeles, San Francisco, and elsewhere. Our lawyers practice in nearly all areas of the law. We have a long-standing established tax credit and finance syndication practice, and we are committed to being a leader in the developing Opportunity Zone program, and are already advising several clients in this regard. Liz Steep will start today with a discussion of the investor's perspective of the Opportunity Zone program. Liz's practice involves advising clients on a variety of federal and state tax issues and in the areas of corporate, partnership, international, and individual income tax. Following Liz, Walter Calvert will discuss Opportunity Zone funds, focusing on what requirements, such as registration and asset tests, exist. Walter's practice focuses on public finance, project finance, federal, state, and local taxation, exempt organizations, and new market tax credits. Following Walter, Gater Aurelian will discuss Opportunity Zone fund structuring alternatives. Gater's practice focuses on a wide range of corporate law matters, including equity and debt financings, commercial loan transactions, new market tax credits, mergers and acquisitions, corporate governance, and general business law matters. Following Gater, Eric Smith will lead a discussion of securities laws consideration. Eric regularly represents private equity funds, hedge funds, venture capital funds, and their investors in connection with portfolio transactions, fund formation, and securities compliance. Following Eric, Robert Gottlieb will discuss real estate project considerations. Robert's practice focuses on structuring and negotiating complex real estate, partnership, and business transactions, representing real estate developers, tenants, management and leasing companies, and investors.
Thanks, Mike. So we're going to start with an overview of the who, where, and what of the Opportunity Zone program. So starting with the who, what does this program do? It tries to attract investors who have existing capital investments to get them to sell these existing investments, take the funds, and invest them in a qualified opportunity fund. And there are two big tax benefits for investors who are able to do this. The first benefit is a deferral, and the second benefit is an exclusion benefit. The deferral benefit allows an investor to defer realization of their existing capital gains until the end of 2026 or when they dispose of their interest in a qualified opportunity fund if they roll over their existing investment into a qualified opportunity fund within 180 days from the date of the sale of their existing investment. The second benefit is an exclusion benefit, and this allows investors the potential to shield from tax up to 15% of the gain on their existing investment and up to 100% of the gain of their investment in the new qualified opportunity fund. We'll get into the economics of how this works in 1 second, but first we should talk about who is eligible for this deferral and exclusion benefit. Generally, it's available for any taxpayer that otherwise would recognize capital gain. So individuals, corporations, partnerships, and other pass-through entities all are eligible. If you are an investor in a pass-through entity, the pass-through entity itself can actually elect to roll over its gain into a qualified opportunity fund, or you as a partner, if the partnership does not make that election, you individually can make that election to roll over your share of the partnership's gain into a qualified opportunity fund. And the way that you're going to report this deferral going forward is Form 8949. This is an existing form that you might be familiar with, sales and other dispositions of capital assets. So now we're going to walk through the economics of the two types of tax benefits, the deferral benefit and the exclusion benefit. So the first benefit is the deferral benefit, and this is available for any investor who sells an existing investment prior to December 31st, 2026. This benefit allows the investor to exclude all of the gain from the sale of their existing investment until the later of December 31st, 2026, or the investor's disposition of the interest in the qualified opportunity fund. So the investor sells his existing investment, uses the proceeds to invest in a qualified opportunity fund, and does not have to pay tax on the gain from the existing investment until the earlier of the investor's disposition of the interest in the fund or December 31st, 2026. If the investor does dispose of its interest before the end of 2026, the gain deferral ends and the investor has to recognize the deferred gain on the original investment plus any gain on the qualified opportunity fund investment. So for example, if you buy stock for $50, you sell it for $150 in 2018, you would normally have $100 of gain. If you make this deferral election, you can exclude $100 of your gain for 2018. You will pay no tax in 2018 as long as you roll over the $100 into a qualified opportunity fund. You'll pay tax on this $100 on the earlier of a sale of your fund investment or December 31st, 2026. The problem here, potentially, is that in 2026, you may be invested in a fund. You have to pay tax on your gain from your original investment, but the fund is not liquid at this point. So you need to plan, if you're going to hold this investment for a period of time, to maximize your deferral for liquidity to pay tax on the deferred gain when 2026 rolls around. The second type of benefits are the exclusion benefits. So there's two types of exclusion benefits. The first benefit is that a small portion of the gain on the original investment can be excluded from income if you meet certain holding period requirements. There are two types of holding period requirements. The first one is a 7-year requirement. So if you sell your existing investment, you roll over the gain into a fund, and you hold your interest in the fund for at least 7 years, you get to exclude 15% of the gain from your original investment. So in our earlier example, we had $100 of gain that we deferred. When the time comes to recognize it, we normally would recognize $100 of gain. However, if you hold your investment in a fund for at least 7 years, you only will recognize $85 of gain instead of $100 of gain. There's a similar rule if you only hold for 5 years. Here it's a 10% exclusion. Using our simple example, if you have $100 of gain and you hold your interest in the fund for 5 years, you can exclude $10, so you only have $90 of gain as opposed to $100 of gain. The biggest benefit is the exclusion of all of the appreciation gain in the fund. So this benefit allows an investor to exclude from taxable income all of the gain that's attributable to his or her investment in the qualified opportunity fund. So in our example, we sold our original investment. We had $100 of gain, which we rolled over into the fund. In 2026, we're going to pay tax on that gain, assuming that we haven't sold our interest in the fund earlier. Let's say in 2036, we sell this investment for $200. At this point, no additional tax is due. The second $100 of gain that's attributable to the appreciation of the fund is not subject to tax because you've held your investment for at least 10 years. The proposed regulations allow the exclusion benefit to be realized up until December 31st, 2047. So this allows an investor to make an investment in a fund as late as June 2027 to hold the investment for 20 years. So you have to hold the investment for at least 10 years to get the benefit of the exclusion of the appreciation in the fund. The IRS has allowed you to hold it for another 10 years and still obtain this benefit in case there's not an opportunity for liquidity at the end of your 10-year holding period. So since the deferral benefit is available for the appreciation of the gain in the fund, the greatest tax benefit is going to be coming from an investment in a low-income community, which we'll discuss later, where there's significant appreciation in value. So some good investments would be a newly constructed commercial office or retail project in an up-and-coming low-income community, because this is something that's going to substantially appreciate in value, hopefully, over the next 10 years. A bad investment will be something like a charter school, where there's not as likely a chance of there being a substantial appreciation in value over this set period of time. So the greater the amount of the appreciation, the greater amount of gain excluded from tax, and the greater amount of the benefit. We'll just walk quickly through this other example. This one is a little bit more complicated. Here we have an investor with an existing capital investment with a value of $10 million, a basis of $4 million, and a long-term holding period. Generally, if the investor just went ahead and sold this investment now, the investor would have $6 million of gain. Assuming a federal tax capital gains rate of 20%, there would be a $1.2 million of tax due with respect to 2018. If you look at the next slide, there's a chart that shows various mathematical computations of how these different exclusion benefits would apply. At the far left column, there is no benefit. You just sell. There is the gain. When you sell your investment, you roll over part of this gain into a qualified opportunity fund, but because you were not eligible for the program, you just pay tax on your gain from the qualified opportunity fund. And the far right-hand column is where you get the benefit of all of the different types of tax benefits. You get the deferral benefit, and you also get the exclusion benefit, both on the 10-year period and on the 7-year 15% period. So as you can see, if you're able to make these types of investments on the same amount of appreciation, you're going to cut your tax almost in half. In terms of timing as to when you need to roll your gain over into one of these Opportunity Zone funds, generally it's 180 days from the date you sell your existing investment. There's a special rule for partnerships and other pass-through entities. As I mentioned before, if you are an investor in a partnership, the partnership itself can elect to roll over its gain into a fund, and in this instance, the partnership would have 180 days from the sale of its existing capital investment to roll over its gain into the fund. If you're a partner in a partnership that has capital gain but elects not to roll the gain over, you as the partner have 180 days from the end of your partnership's taxable year. So if the partnership sold a capital asset, let's say this year on the first of the year, and decided not to roll over the gain, you as a partner have until June 30th of next year to roll the gain over into a fund. So this is a great benefit if the gain that you're looking at is gain that's attributable to a partnership. It really extends the amount of time you have to roll over your gain into the fund. There's also a special rule: if you dispose of your entire investment in a fund, you can roll over the gain into another fund to continue this benefit of deferral.
Liz, I might just pause you there and comment on something you were saying there, and that's these are all federal rules. There's going to be a whole state aspect of this also, which we really don't know about. But in general, I think if the state conforms to federal rules, these same benefits will carry over to state income tax. But if a state either has some non-conformity or isn't an income tax state, you won't get these at the state level.
That's correct. To the extent that a state conforms to the federal law, so we're in Maryland. Maryland generally conforms to federal tax law. To the extent that your gain is excluded for federal income tax purpose, it similarly would be excluded for state income tax purposes. But if you're in a state that does not conform to federal law or adopts a different type of provision with respect to the specific type of gain, you may be in a tax position there.
A couple of other observations. One is a lot of taxpayers have to appreciate the distinction between the rollover of gain into an opportunity fund compared to a like-kind exchange, because in real estate people are thinking that it's a form of a like-kind exchange. Note that, as Liz described, here we're investing our actual amount equal to our tax liability, whereas in a like-kind exchange, you're investing the gross sales price of the relinquished property. So that, as Liz portrayed it, you should be doing some cash planning with respect to the triggering of the deferred gain, which will occur upon disposition of your interest in the fund or the end of 2026, whichever occurs first. On a related note, a lot of what we're describing is way beyond the scope of the statute and is contained in the first set of proposed regulations that came out. The statute is not nearly as in-depth as the guidance that's required to structure an investment in an opportunity zone fund. One of the areas, for example, that there is an absence of guidance on is how you are disposing of your investment in the opportunity fund. By statute, each individual is disposing of their interest in the fund, which presumably is going to be either a stock interest or a partnership interest. In fact, most commercial real estate is disposed of with the asset itself being disposed of. And there is not a link between what happens if the partnership vehicle sells its asset before the fund interest of an individual investor has been sold. But we do look forward to getting regulatory guidance that will achieve that result.
Liz, if I can interject a question we received. The question we have is, if an investment in the fund happens after 2018, is there a problem of not having the 7 years to get to the end of 2026 and therefore a risk of losing the 15% exclusion that you mentioned a few minutes ago?
Sure. So you basically have until the end of 2019 to roll over your gain into the fund, and then you would satisfy the 7-year holding period. But yes, if you want to maximize your benefits and get the 7-year 15% exclusion, you're going to have to make this investment before December 31st, 2019. Similar rule with the 5-year rule. If you're going to roll it over to get the 5 years, it needs to be before December 31st, 2021. To the extent that you make an investment after December 31st, 2021, you still can benefit by A, the deferral on your gain until the end of 2026, and B, the potential exclusion of all of your gain in the opportunity fund if you hold it for the 10-year period. But if you're thinking that you want to get that 7-year benefit, yes, you're going to have to roll over within the next year. So we'll just move on to the where of this. Where are these investments going to be made? We've made a lot of reference to the qualified opportunity zones. All the qualified opportunity zones have now been nominated, certified, and designated. As part of the Tax Act of 2017, the governors of each state were instructed to identify areas they thought would be good qualified opportunity zones. These areas had to meet certain standards, including a poverty threshold and a low income threshold. Once these were nominated, there were certain zones that were certified and designated, and those are all available that you can see now. There's a link here that you can actually type in an address and see whether or not it's in an opportunity zone.
This is Walter. I'm going to talk about funds. And I'll start with sort of where Liz left off. So we've got an investor. It's December. Let's say the investor has an asset that they just sold off for $15. Their basis in the property they had was $5, so they got $10 of gain. And they may be anxious. It may be their 180 days is running against them, and they need to find a fund or create a fund. Our topic is, well, what is a fund? And in the world of tax law, what the IRS gave us, Congress gave us, is about as simple a creature, an investment entity, as we could ask for in terms of the requirements that tag to what we need to do to get ourselves a fund. I chopped it up in sort of 4 basic requirements, and it starts with, under tax law concepts of what is an entity, we've got to have a corporation or a partnership. I'll come back to that, the nature of the entity, in just a minute. It needs to have a purpose of, quote, investing in qualified opportunity zone property. That's a key piece that we'll spend a fair amount of time on as we go forward, is this test that's got to have at least 90% of its assets invested in zone property. And lastly, it's got to self-certify with the IRS, which, as it turns out, is a very simple process and has some flexibility that it provides us in terms of whether or not you have a fund. So in terms of creating your fund, today you've got your $10 of gain, you're anxious to put it somewhere. You can go out and find one of these funds that's out there on the market somewhere, or you can call your attorney up and have them set up a fund. And typically one would either go and form a state law corporation, and that corporation for federal income tax purposes could be a regular type C corporation, or it could elect to be an S corporation. Or alternatively, you could form a state law partnership, limited liability company. And the key is for that it needs to, under federal tax law, be a partnership, which, and this is a question I frequently have to refresh everyone on, is to be a partnership you have to have two members. You can't go with a frequent route of setting up a limited liability company with just one member, because for federal income tax purposes, that poof becomes a disregarded entity. So if you go the partnership route, you need to have at least a second member in it, which for big funds isn't a problem, but if you've got a standalone real estate development, you need to make sure it's got a second member in it. Does it need to be a new entity? No. You can take an existing entity and with just little magic turn it into a fund. The real magic is that the organic documents, whatever form documents you're using to set up a fund, should include language that includes this purpose of being a qualified opportunity zone fund investing in zone property. So the certification process itself involves going to the IRS, but it happens later. So take my simple example, $10 today, you set up a state law limited liability company tomorrow, you put the right language in its organic documents. It doesn't actually really turn into a fund until sometime next year when you file its tax return. At that point, the IRS has offered us a draft of a new form, Form 8996, that will get filed with that tax return, which include boxes to check which indicate that the entity for which the tax return is being filed has elected to be an opportunity zone fund. Self-certification process. There's nothing you get back from the IRS that validates that your entity is an opportunity zone. You simply file the form. And there's probably a little bit of planning here, if you're trying to be crafty in the sense that you can create a fund today and you don't really turn it into a fund until next year when you file your tax returns. But if for some reason between now and then one chose to decide that the $10 that went in, you've had some better opportunity come along and you want to take 10 other dollars you had that represents your gain, you could potentially, before self-certifying, put it into a different vehicle and deem that to be where your rollover was. General themes on the concept of funds. You've got your fund, your own fund, somebody else's fund. You take your $10 of gain and roll it into the fund. A key requirement for this program is to be an equity investment in the fund. Can the fund have other equity? Yes. Can the fund have debt? Yes. Can the other investments be from sources other than capital gain? Yes. This is where it starts to get complicated, and we won't get too deep into this today, but I may take my $10 of capital gain and put it into a fund. Liz may take her $5 of capital gain and put it into a fund. My colleague Robert here may say, well, I like your investment. I got $5. Can I put it in? And I say, yeah, I need $20. So he may put his $5 in, but it may not be part of the qualified piece of the fund that gets the tax benefits. There may be sort of silos within the fund that have qualified pieces and non-qualified pieces, which the accountants will have a wonderful time doing the math to separate it out on. The 90% test. So I put my $10 in, and each fund will have two testing dates, the end of its calendar year and 6 months into its tax year. And at each of those testing dates, it's got to evaluate whether of my $10, my example, at least 90% of that has gone into a zone property. And so there's probably a slide I've got, this is probably the most important slide of anything for discussion today, is so $10 into the fund I put in, $90 has to be in zone property. If I put that in today with a calendar year-end tax return, the first testing date is going to be December of this year. And the question will be, is 90% of my $10 gone into zone property? So what is zone property? I think of it really as being two categories. Either it is the fund directly investing in a business activity, owning the assets, conducting the operations, paying the employees in an opportunity zone, or, and this is the far more likely case I think we're going to see is the fund taking its monies and putting them into another entity, either a partnership or a corporation. And I think the single most important point is at the bottom of this page 21 that I will make today, is that if the fund takes my $10 and I have the fund invested into another, say a partnership as an equity investment, that satisfies the 90% test. And so that's probably going to be the predominant model we see, because in my example, if I put $10 in today, I'm getting tested at year end, and it's dubious I'm going to be able to qualify my $10 unless I promptly invest it in another entity, be it a partnership or corporation. So the testing, where does it lead to? If you fail the testing, it ultimately leads you to a penalty. And that the simple math for the testing is at each of the two testing dates, 6 months into your tax year and at the year end, you do the test. If you're below, and you average the two numbers, so that if you average out at, say, 90% one test and the other test is at 70%, you average at 80, and you fail the test, and you have to go, and then when the Form 8996 gets filed with your tax return, there's a penalty you have to report based on a month-by-month calculation of the penalty. So I think that's all I've got on fund overview. Again, the single most significant takeaway is put $10 or whatever into a fund representing capital gain, gather at each testing date, 6 months in, and at year end, have 90% of that invested in qualified opportunity zone property.
One thing to watch out for at a business level is the cohabitation of rollover investors with non-rollover investors, because their goal with respect to the ultimate assets in which the opportunity fund investment is being made may differ. The principal example being if the business plan is to hold the asset for as long as possible, it may be that the step up in basis that the rollover investor is looking to achieve will have that investor indifferent to ups and downs that may be being endured, whereas an investor who's not getting those tax benefits may indeed say it's time to dispose of the property because we've maximized value. So you may have differing views with respect to the liquidation of an investment, and the issue is going to be to whom is the sponsor of that project really going to be listening to, the rollover investors or the after-tax investors.
Thank you, Robert. Gutierrez?
Thank you, Robert. So our next part of the presentation will be to focus on structuring the Opportunity Zone Fund. And the first consideration in any type of decision as to how we're going to go about structuring your fund will be to look at, well, what are we going to invest in? We have to invest in zone property. So let's look at the definition again. So a fund has the purpose of investing in qualified opportunity zone property, which we will refer to here as zone property. And at least 90% of the fund's assets must be in zone property, as Walter alluded to earlier. So zone property can be one of three things, right? And there are really two categories, but one of three things: qualified opportunity zone stock, qualified opportunity zone partnership interest, or qualified opportunity zone business property. So just looking a little bit deeper at each of those types of investments, qualified opportunity zone stock is an investment in any stock of a U.S. corporation if the stock was purchased by the fund after December 31, 2017 in exchange for cash. So we have the type of investment in our time frame. So it has to be after the Tax and Jobs Act was passed. And the stock has to be issued by a qualified opportunity zone business or a corporation organized for such purpose. So I'll just stop right there. So it's either an existing business that meets the definitions of what a qualified opportunity zone business is, or you've set up a business brand new for the purpose of investing in a qualified, of investing in a qualified opportunity zone. The other consideration is the corporation that you've invested in has to remain a qualified opportunity zone business during substantially all of the fund's holding period.
Tara, I would note that in the regulations, we've got that phrase substantially all shows up quite a few places. I don't know, at least 5 I noticed. They gave us one definition for one particular test, that's 70%. I think all the others, we really don't know yet what substantially all means. So it's a nice phrase, but we really don't know yet.
So you'll see that I'll get into that a little bit when we discuss what the qualified opportunity zone business is, and you'll note that there are quite a few holes, as you mentioned, in what these definitions actually mean. The second type of zone property is, of course, an investment in partnership interest. So similar to the stock purchase, this is any capital or profits interest in a domestic partnership if it's purchased again after December 31, 2017 in exchange for cash. And at the time the interest was purchased or the investment was made, the interest was issued by an existing qualified opportunity zone business or a partnership that's been set up in order to become a qualified opportunity zone business. So it can be a brand new entity. There we go. And also, similar to the stock investment, the partnership that's being invested in has to remain a qualified opportunity zone business, again, during substantially all of the fund's holding period. So the first thing we need to understand then, okay, well, what is a qualified opportunity zone business? So a qualified opportunity zone business is any business or trade that owns or leases substantially all of its intangible property and zone property. So this is the only place where we're going to get a definition of substantially all, and that means 70% or more according to the regulations. So everywhere else that we've used the phrase substantially all, we're not really sure what that means. We're not sure if it means, for example, holding your interest in a fund for substantially all of the fund's holding period. Does that mean, 90% of the fund's holding period for 9 out of the 10 years? We don't know that yet. But we do know, and this is an important consideration, that 70% or more of the business's assets need to be in an opportunity zone. Also, that it generates at least 50% of its total gross income from active business. So this is not passive activity. It can't just be simply a holding company that's not conducting business. It uses a substantial portion of its intangible property in the active conduct of business. So this will be more relevant and important for companies that have a lot of IP and how you're intending to use your IP. So it's an important consideration if a substantial portion of your business model involves the use of IP, it's important to note that that IP needs to be used in the active conduct of a business in order for the business to qualify as a qualified opportunity zone business. The qualified opportunity zone business also has to maintain less than 5% of the average of the aggregate unadjusted basis of its property as non-qualified financial property. And as I will discuss this a little bit later, is that the most important consideration for us here is, well, what do we do with working capital? So the fund has all this cash, we've raised all this cash, we need to maintain cash in order to take care of the business of the fund, paying salaries and et cetera, and purchasing supplies. Well, if you can only maintain less than 5% of that to be deemed as working capital, that's where we're going to run into some sort of an issue, and there is a working capital safe harbor that will address this area. And lastly, it can't be an ineligible business. So this is just a quick list. If you look at the slide here of ineligible businesses, this is what we refer to in the industry as sin businesses. So these businesses, country clubs, massage parlors, liquor stores, etc., they don't qualify as qualified opportunity zone businesses, even if they're located right in the middle of an opportunity zone and would otherwise satisfy all the other requirements of a qualified opportunity zone business. So the third type of zone property is the qualified opportunity zone business property. So the qualified opportunity zone business property is tangible property that's used in the trade of business of the fund, and there's 3 caveats. If the property was purchased by the fund from an unrelated party after December 31, 2017. It's a bit less stringent in the opportunity zone world as to what constitutes an unrelated party. Normally it's 50%. Is considered unrelated, but here the regulations have pointed us to the 20% threshold. So as long as the seller or the previous owner holds less than 20%, it will be deemed unrelated for the purposes of the purchase and qualification. The next caveat is the original use. So the original use of the property has to commence with the fund, or the fund has to substantially improve the property. And we'll discuss particularly the substantially improving the property requirement. And lastly, again, during substantially all the fund's holding period, the use of such property was in the opportunity zone. So, and this goes towards maintaining the goal of having investments focused on low-income communities. We don't want investments that are leaving the communities after they've started there for the purposes of qualification. So what is meant by substantially improve? So a qualified opportunity zone business property is deemed substantially approved by the fund only if, during the 30-month period beginning after the date the property was purchased, that the improvements exceed the adjusted basis of the property when acquired. This is simply referred to as doubling down. And the reason for that is we were looking to double the value and the basis of the property. Regulations have noted that the basis of land may be deducted. Now, that's an important deduction for the purpose of real estate, because oftentimes you'll find that the value is really in the land. And so it would create an enormous burden or threshold to cross over if we had to include land in the price of what we need to double. So a simple example here, the fund acquires a property directly for $100,000. Of that $100,000, $25,000 is attributable to the land and $75,000 is attributable to the building. So the fund then is required to invest an additional $75,000 in the property for it to qualify as zone property. It'll have been deemed substantially improved. And at the end here, there's a simple quote that explains the thought process behind excluding the basis of the land, because it allows for repurposing of vacant buildings in qualified opportunity zones. So it's important to always keep in mind the legislative intent of what opportunity zones were designed to benefit, and they were designed to benefit low-income communities. And the regulations, even for things that we're not sure of, I think will create pathways to encourage those types of investments. So we noted earlier about the working capital safe harbor, and I'll stop here for just a little bit. So now that the fund has gotten money in and investors have put in all their gain in this fund, and the first thing the fund has to decide is, okay, well, one, what type of zone property am I going to invest in? Am I going to invest in equity interest in a qualified opportunity zone business, meaning I'm going to purchase stock or partnership interest in an existing or newly formed qualified opportunity zone business? Or am I going to purchase property directly, the factory in an opportunity zone? So let's recap. So for an qualified opportunity zone business, and this is just for a business and not direct investment in a zone business property, non-qualified financial property is limited to 5% of the aggregate unadjusted basis of the property held by the business. So therefore, business can't hold more than 5% in non-qualified financial property, except for reasonable amounts of working capital, which are 5%. However, the regulations have provided a working capital safe harbor for fund investments in qualified opportunity zone businesses that acquire, construct, or rehab tangible zone property, which includes both real property and other tangible property used in a qualified opportunity zone business. So there are three primary requirements to meet this safe harbor. And again, this is with respect to a qualified opportunity zone business. So working capital is deemed reasonable if, one, the business has developed a plan that identifies the cash that's being held for the purposes of acquisition, construction, or substantial improvement of the property. So that's an important note. So the fund has raised a lot of money from various investors. The plan needs to be, well, we're going to use this money from the business's perspective in order to invest in tangible property and opportunity zone business. So if we have a potential development in sight, that's the type of plan it's looking to work with. The second requirement is that the business has to have a schedule of how the cash will be used within 31 months of the acquisition. So that's a much longer time frame than the 6 months of semi-annual testing periods. So technically then, the business has 31 months to use that cash in order to satisfy the requirements of the qualified opportunity zone business. And thirdly, once we've set up a plan and a schedule, the business actually has to use the working capital in accordance with that plan and schedule and try and keep on task. So with that type of background, there's really two options, right? You'll have a single-tier fund. And the single-tier fund here, as you see in our illustration, basically you have the opportunity fund and it invests directly in qualified opportunity zone business. So it's holding title, it's investing directly. So the 90% test applies, so 90% of the assets of the business, of the qualified fund, of the business must be zone property. So if you've invested in a factory, for example, that's located in an opportunity zone and the fund has invested directly and has purchased the land, purchased the building, and has invested all of its assets in purchasing and developing this factory, we're fine because the factory will meet the test and so will the fund that has invested 90% of its assets. However, note here, with this direct investment in the factory, so a direct investment in qualified opportunity zone business property, there is no working capital safe harbor. So the fund could not hold more than 10% of its assets as cash. And all IP, for businesses that are heavily IP in focus, all IP would also count towards the 10% of the assets that can be non-zone property. So there's a limitation there, and it's a significant thing to think about. So this illustration shows how that fund would be structured. You have your sponsor and your investors who will invest and form the fund. Your investors as limited partners, your investor generally as a general partner. You have invested into a fund that's formed as a limited partnership, as an example. So the fund invests directly in business property. The 90% test applies. That's great, so long as 90% of the fund's assets were used in the qualified opportunity zone business, meaning the factory at the end. However, there's no working capital safe harbor, so that means 90% of the assets must be deployed by the testing period. So you'll note that if it's the factory here, 90% of the fund's assets have to have been spent within that first 6 months of the testing period of when it's designated as a fund. The other option, which we think will be the more utilized option, is the two-tier fund structure. So a two-tier fund will invest directly by holding equity interest in a corporation or a business operating as a qualified opportunity zone business. So instead of investing directly into the factory, the fund will invest into a business, which will be a subsidiary of the fund, that will hold title to the property itself as opposed to the fund investing directly. So the other slide will show you, so again here, the two-tier fund, the 90% test still applies to the fund, so the fund still has to invest 90% of its assets, but except this time, rather than investing it in zone property directly, it's investing it in a qualified opportunity zone business. The important part here is that the business itself is required to hold 70% of its assets in zone property. So that's what the substantial all test in the qualified opportunity zone business told us. And we also get the benefit of working capital safe harbor. So the business has 31 months to deploy the capital according to its written plan and schedule. So now the business itself is going to invest in that factory at the very end. So if you look at and you do the math, the fund has invested only about 63% of its assets in the qualified opportunity zone property, working through a subsidiary in this two-tier structure, as opposed to, and if I go back just a tad, as opposed to investing directly, where all 90% of the fund's assets would have been invested in that factory to achieve the same result.
Tara, I would make a couple comments. Go back to your picture there, why don't you?
Mm-hmm.
So when I go through our proposed regulations, I've counted, I think, like 7 distinctions between whether a given test you come out better by having 1 tier or 2 tiers. And of the 7, only 2 favor the single-tier approach. One of them is the test you mentioned, the SIN test. I think it was just a flaw in the drafting of the statute. The SIN test that you can't do massage parlors and other things doesn't apply up at the zone level. The fund could in fact build a massage parlor in the zone and it wouldn't be prohibited. But if it drops the money into an entity below it, it does. And the other is a trader business test that the fund level avoids the active trader business test. But the other 5 tests, the primary one of which is the 90% test being satisfied, really favor the 2-tier structure. So there seems to be a lot under the proposed regulations we now have that favors the 2-tier structure.
But this is the structure that I think most funds will opt to use. And with respect to, there are lots of open questions, but with respect to the SIN businesses, That is exactly right. So if you read the statute as it's written, technically, because it doesn't fall under the definition of a business, the fund can invest in what we normally define as a sin business. But I'm suspecting that the regulations will clarify that. I think that might have been, a loophole in terms of drafting errors.
To be clear, the sin businesses could be tenants of a retail property, where the retail property was the business, as opposed to the operation of the sin business being the business.
One other comment I would make in your diagram there is under the qualified operation of business level, you've got the 70% substantially all test. When I talked about the 90% test up above, I described how that very specifically applies at 2 testing dates and how there's a penalty. With the 70% test, as best I know in the regulations, we really don't have any timing type rules. It's kind of a test that's there, but we don't have a nice, neat timing rule at this point that tells us how you apply it, or does the whole thing explode if you just don't meet it. So to me, that's another major gap yet to be filled in by the regulations, is more detail on timing and results, safe harbor for the 70% test.
A question we got while we're talking about the sin businesses, do you guys have any views on whether a cannabis business would be something that could be participating in the program?
I have to say I'm not aware of anything that explicitly prohibits it at this point.
Although consistent with federal policy, where it is fully illegal, one would wonder whether the fact that it's federal tax legislation would somehow suggest otherwise.
Yeah, it's curious. I mean, if you had a marijuana dispensary, could you not take depreciation deductions for the building you're using?
You want to get into taxation of the cannabis business?
I don't know. Just throwing that as an analogy of how it goes.
Okay.
Thanks, Gutair. This is Eric Smith, and I'm going to get into securities law considerations. A lot of these considerations are not new. They, unlike much of what Walter, Liz, and Gutair were talking about, these are applications of the existing securities laws to the Opportunity Zone fund world. First, I'll talk about kind of potentially applicable securities regulations, then give a summary of those regulations, and then try and give a sense of the impact of being subject to those regulations. The four sets of statutes that are likely to apply when you are dealing with forming and operating a fund or raising capital either for the fund or for the underlying businesses in which the fund invests include the Securities Act of 1933, the Investment Advisors Act of 1940, the Investment Company Act of 1940, and the Broker-Dealer Licensing and Regulations under the Securities Exchange Act of 1934 and FINRA regulations. So one of the basic things to keep in mind whenever raising capital by issuing securities is that there is just 3 types of offerings: a registered offering that is registered with the SEC, an exempt offering, or an illegal offering. So there's not anytime you're getting into issuing securities, you have to somehow address the fact that you're issuing securities and have to comply at the state and federal level. The 33 Act application to raising capital for an Opportunity Zone fund that is generally the exemption from having to register with the SEC, that offering that is generally going to be used is likely the private offering rules, which is sometimes referred to as a 4A2 private offering. Under that requirement, there are also state level requirements, and regulations promulgated under that rule are the Regulation D requirements. one of the benefits of using Regulation D, aside from being just a clean offering when you do a private offering, is that you also get state preemption if you do it under Rule 506, so that you then don't have to look at the 50 different states where you may be trying to raise capital for people that are interested in investing in the Opportunity Zone Fund. The other place that this comes up is when the fund is investing in an operating business or investing in a limited partnership or LLC that is going to be the operating business. When that entity issues LLC interests or stock in the or limited partnership interests in that entity to the Opportunity Zone Fund, that business also needs to comply with the Securities Act of 1933. That too will generally be done through the exemptions as a private placement done in compliance with the Regulation D requirements. Another piece that generally applies to funds, and oftentimes people struggle a little bit with why there would be an investment advisor concern when it comes to funds, but an investment advisor under the Advisors Act is any person who, for compensation, engages in a business of advising others as to the value of securities or with regards to the purchase and sale of securities. The way that that applies in the fund world is you have a fund and it takes in its capital and then it invests in the operating businesses. The advising of others that's being done is the entity, usually a management entity or a general partner, that is advising the actual fund about the investments that it is making into businesses. And once you have someone advising that entity about investing in securities, you have to address the investment advisor regulations. If you're over $100 million in assets under management for the advisor, not just for the fund, you could have multiple funds, but if an advisor has over $100 million in assets under management, then it would register with the SEC. If it's under that amount, then the state law would be the requirements, and most states do require some type of registration. The piece to be clear there is that you are prohibited from registering with the SEC if you are under $100 million. There's some wiggle room that goes back and forth as you are around that number if you go over or below it, but as a general matter, 100 million is the limit. Some examples that where that applies. I think I already mentioned these, but where you have an Opportunity Zone Fund investing in real estate that's not a wholly owned and controlled by the fund, gets into that investment being a security, or the Opportunity Zone investing in an operating business and where they're issuing securities. That's where the person advising the fund is deemed to be advising with regards to securities. Which gets to one of the fundamental questions of what indeed is a security, which has been discussed for decades. But when you talk about an LLC interest, a stock, notes, partnership interest, mortgage interest, asset-backed securities, tenant in common interest, any place where there's kind of a common activity, you're likely to have a security, which is going to trigger both the 33 Act requirements that I mentioned before and review of the Advisor Act registration requirements. The Advisor Act requirements are substantial. When you have to register, there's a filing requirement with the SEC where you fill out your Form ADV, which provides detailed disclosure regarding advisors, investments, strategy, and those types of items, including a disclosure brochure that describes what it is that the advisor does. There are requirements regarding complying with record-keeping obligations, that address advertising, trading, operational documents. The advisor also then becomes subject to SEC examinations, is required to put in a compliance program and designate a chief compliance officer, and then implement written codes of ethics and comply with custody requirements. There are some exemptions, as this list kind of looks at can seem daunting. There is some exemptions there for exempt reporting advisors, which is for an advisor that is just advising qualified funds, and a lot of private equity funds, hedge funds, and my assumption is that opportunity zone funds will seek the relief of being an exempt reporting advisor, because while you still have ADV and other filing requirements, many of these restrictions either go away or are substantially reduced if you can qualify as an exempt reporting advisor. The next topic that needs to be addressed is compliance with the Investment Company Act. And if you are an Investment Company Act, there is a registration or exemption requirement again. An investment company is a company that is or holds itself out as being primarily engaged in the business of investing in securities. So an opportunity zone fund that falls within that world, as opposed to investing directly into real estate, instead investing in ownership interests in real estate or in businesses issuing securities, would have to address the requirements of the Investment Company Act. There are 2 or 3 regular exemptions that are used, but they impose some restrictions on how the Opportunity Zone Fund can be set up. One of the most common is that there are less than 100 investors. So if you have a limited number of investors in the fund, you're below 100, then you're likely exempt from this act. There's another exemption where you can have an unlimited number of investors so long as they are all qualified purchasers, which as a general matter for individuals means they have $5 million in investments, or for institutional investors have at least $25 million of qualifying investments. The third, and one that may apply in this context again because of the likely heavy real estate portion of Opportunity Zone Fund opportunities, is an exemption for investments in mortgages or interests in real estate. So again, you get to interests that are tied directly to real estate that may allow an exemption under the Investment Company Act. For most purposes, private funds find some type of exemption in one of these 3 ways, because the regulatory overlay, if you don't, is substantial. The final topic that I wanted to touch on briefly is the broker-dealer regulations, which arise when either the Opportunity Zone Fund is trying to raise capital and wants to find someone to assist it in raising capital, or the businesses are trying to raise capital and they want to get someone to help them contact a Opportunity Zone Fund to help them raise that capital. Under the rules, a broker is any person engaged in the business of effecting transaction in securities for the account of others. If you're classified in that way, then you need to be licensed and comply with a number of other requirements. The basic idea here is if you have someone that is being paid to help raise capital and frequently an indication of being a broker is getting some type of commission or other salesperson's interest in the closing of that sale, will raise questions of whether or not the person is a broker-dealer. And both the issuer and the broker-dealer can be subject to penalties in connection with engaging in those transactions without having been properly licensed. So all of this raises the question from 33 Act, 34 Act, Investment Company Act, and Investment Advisors Act of, are you investing in a security? Because a number of times people will say, no, I'm just investing in real estate, or is it really a security if it's a small company where there's just two people? The definition of security, which I have up here from the acts, includes, as I note at the end, something called an investment contract, which, in addition to typical things like stocks, certificates of interest, profit-sharing agreements, it brings in a lot of different items that will cause things to be securities that aren't expected to be securities, and as a result will cause all of the regulatory overlay that I mentioned to be applicable. The general idea is that it's any investment of money in a common enterprise with an expectation of profits from the efforts of others. So if you think through those in some detail, you get to the point that it makes some sense in that you're investing in a way, if you're offering investment where other people are looking to profit from your activity, it likely is a security, and the applicable securities laws are likely to apply. Just wanted to quickly note a couple of items that are likely to be applicable here. LLC interests in a real estate investment will likely be securities unless it is a wholly owned LLC. So if the fund were to invest in one piece of real estate that happened to be held by an LLC, was the 100% owner, that would be clear that that's all that they were doing, then those are not investments in securities, which would alleviate the requirement to register as an investment advisor. I noted, because California happens to have been fairly clear, other states have not been as clear, but that California presumes that it's a securities unless all members are actively involved in the management of the business, and that gets into the question of efforts of others. So if the Opportunity Zone Fund is managing the real estate, you can make a clear argument that it is not a security. There are other items that come up, like investments in promissory notes where people are making loans, and if it's a series of notes, then it's likely to be a security. If it's a single note secured by real estate, then it's less likely to be a security. On the joint venture side, you're likely to have a security for at least one of the parties if they are not the controlling party of the investment. And just as a quick summary, which I'd noted as I went through, there's the four different acts that are likely to apply whenever raising capital or investing in securities. And I think that's it for me.
Eric, I have a question. With respect to the Investment Company Act and the exemption attached to investments in real estate, tax lawyers always deal with directly or indirectly. Do you view that as a direct or indirect test, especially given the fact we're going to have more likely than not, have two-tier structures in our funds, so that the money-raising vehicle will likely then be acquiring a partnership interest or an LLC interest in a lower-tier entity, which will in turn own the real estate investment?
I view it as, if it's an investment purely in real estate, then yes. When you start to getting into whether or not it's mostly real estate, but it's also arguably an operation of a business, it becomes less clear that exemption's available.
Right. Thanks. This is Robert Gottlieb. I'm batting cleanup, and we'll deal with issues of investing in real estate projects, but more likely we'll be raising more questions about investment in real estate projects than coming up with a roadmap. So that first set of issues pertain to the requirement that we have acquisition by purchase as you remember, one of the operating rules that we have. The acquisition by purchase rule applies with respect to 20% or less overlapping ownership by a current owner. On a regular basis, I'm receiving questions. We already own property that's located in an opportunity zone. We want to make it into an investment that's eligible for the tax benefits. How do we do it? So the simple solution would be sell the property to an entity in which you do not exceed a 20% ownership. So you will have an acquisition by your opportunity zone business, by purchase from an unrelated taxpayer. That would make whatever you purchased and sold and eligible for the opportunity zone business rules. Too often we have clients who say, I understand what you're telling me, but that's not the result we want. We want to own more than 20%. And the issue then becomes, what flexibility do you have? And more importantly, the issue becomes, well, how can I structure a deal that gives my current owner, my client, a greater than a 20% interest? So the first thing we hit upon is tried and true aspect of real estate investment is, what about promote? Can my seller not only own 20% of the purchaser, but also have a participation above a 20% based on the profitability of the entity? Under more general income tax principles, the answer would be that a promote interest is not a capital interest in a partnership vehicle, and we would test the ownership amounts for purposes of related taxpayer based on the capital interest and not based on the profits interest. We don't have any guidance, and it's questionable whether we'll ever get guidance like that in the opportunity zone area. So we proceed at our own risk. For example, can I have a profits interest that kicks in once all capital's been returned? Can I have a profits interest that kicks in once there's been a rate of return, some kind of IRR, some kind of waterfall return? Would that work? What happens if I have preferred equity in the venture? How does that count towards the ownership interests? Some preferred equity has residual participation. Other preferred equity looks like mezzanine debt. The question is, how do you characterize that ownership for purpose of determining how much the prior owner of the property owns with respect to the newly created entity that's going to acquire the property by purchase? Alternatives to acquiring by purchase. What happens if you ground lease the property? It's fair to say that there's really no address in the statute with respect to how one goes about structuring a lease. Can you lease property from a related taxpayer? Do you have to have the tenant, ground lease tenant, be unrelated? All good questions which are being posed to us on a regular basis. We heard about the 90-70 tests. If you indeed create a ground lease relationship between the current owner of property that's located in the opportunity zone and a tenant, what is the rate of return that the lease has to provide? Can you have a participating ground lease? Those are regularly entered into in normal commercial real estate. And the question, without the owner of the ground being treated as a partner, quote unquote, can you borrow that vehicle so that the ground owner can get additional participation on the tenant side without violating a related taxpayer rule?
Robert, before you move on, I might just backtrack to where I was at a 90% test and where Gutierre was with a 70% test. I guess your starting point is if the purchase is from a related party, we don't have the qualified type property we have, and we flunk those tests right out of the gate.
Yeah,
essentially.
The issue is if you are acquiring ground and you acquire it by purchase, the ground itself, if you acquire from a related taxpayer in the 20% rule, won't qualify. The permutation of that question is, well, what happens if I build improvements on that property? So let's say the property that was sold by a related taxpayer was either vacant ground or had some building on it where you're going to have a substantial rehabilitation. You're going to incur the 2x of improvement costs that are prescribed by the legislation. And the question we have is, does the tainting of the ground as a qualified Opportunity Zone business asset apply to the improvements? Or are the improvements a discrete asset so that the improvements will be eligible for the tax benefit that were described earlier by Liz versus the entire project now failing?
And can you tell us the answer to the hypothetical?
I cannot tell you the answer to that question. Even if you were paying me, I couldn't tell you the answer to that question. Alternatively, as a structure, you don't do a sale. You have a capital contribution. Let's say we have someone who's owned land, is interested in participating, and doesn't want to face a taxable disposition of the property. Caveat, it could be a taxable disposition, and you could invest your the amount of your tax cost into the fund. But let's just say it's a matter of lack of availability of capital. So one of the ways you're going to raise equity for the deal is to actually have a capital contribution by the current property owner. Question, is that something which taints the ground because it wasn't acquired by purchase? I think the answer is going to be yes. The question again then becomes, does it taint the improvements that you may make on that land, or the substantial improvements you may make on an existing building? We don't know the answer to that question, Walter, but going back to your question, we do know that for the 70% test, right, that ground that's contributed will not be part of the numerator where you have to have 70 over 100. It'll be part of the asset base of the denominator, but it will not be part of the numerator. So even if you can get past the tainting issue, you have uncertainty with respect to how's the arithmetic going to work with respect to the 70% requirement. And by the way, that's another reason why we're not going to see single-tier structures. You don't want to have to face a 90% threshold, which will even be more difficult to achieve. So you get the relaxation with the 70% in that lower-tier vehicle that's actually going to own the Opportunity Zone business. A lot of discussion about and I'm going to use the words true fund versus rifle shot investments. Do we have expectation that people will be forming large funds? Clearly, everything we read about and hear about is that there's lots of organizations contemplating raising vast amounts of capital to go into fund investments. From my observation, the complexity that's introduced because of the requirements, and we're going to assume they're going to be two-tier, but remember, when you form that second tier and you posit the capital into the lower tier entity, which has to be done within 6 months of the capital being raised, it has to go into an entity, and in order to qualify under the working capital exemption, it's going to have a 30-month plan for how it's going to spend those funds. And it strikes me that unless there are significant numbers of projects which are all teed up to go, raising that much capital, in mass amounts of capital in a true fund, will be finding difficulty in launching it properly so that you can adhere to both levels of the arithmetic tests associated with qualifying the investment. There's been some discussion about the use of leverage in investments. One of the first questions we had was, can you really capitalize your real estate project in the fashion that you typically do, which is 25% equity, 30% equity, 35% equity. And raise the balance of the funds with traditional mortgage debt, construction financing, rolling over into some kind of permanent financing, interim financing. And the question was answered in the regulations, which tell us that the borrowing by an opportunity zone business is not an equity investment by anybody. It is just debt. So that you can get the benefit of the leverage in creating economic yields that would be much higher if you had that will be much higher than compared with a deleverage deal where you had to have all that equity, or that using debt would somehow be dilutive of what your ownership interest was in the fund. So that, by way of example, it's 35% equity and it's all rollover funds and you have 65% debt. The concern was, before we got the regulations, was that, well, you've diluted how much of that project is eligible for opportunity zone treatment by 2/3, because only 1/3 was financed with rollover funds. We have clear guidance that the entire amount of the debt will not affect at all the calculation of how much of the fund is owned by an investor.
That's here, and that's a really big point, because you're here saying I could take my $10 of gain, roll it in, I could borrow $90 inside the fund, get a $100 investment, and then if I put all that together, my $100, when it accrues up to $200, I get to exclude all that $100.
Assuming a 10-year hold period.
Assuming I meet
Every 10-year hold period, and assuming we get clarity that we can sell the property and not have to sell our interest in.
Or I sell my interest in, yeah.
Right.
But I'm not limited to somehow siloing the 90 of borrowed from the $10 I rolled in, so to speak. So it's a,
that is correct.
Robert, can I ask, this relates to some of various questions we've actually received from some of the participants today. Is there any limits on what we could do with that refinance debt? If we didn't need all of the money for the project itself, could either the Opportunity Zone business use that leveraged money to invest in other businesses? Could any of that money be distributed to the owners of the fund?
Well, I think you've asked two different categories of questions. The first question with respect to the fund buying more assets, the answer is going to be strictly a matter of satisfying the 70% test. Right? And will I have a balance sheet that reflects 70% of my assets are in Opportunity Zone located assets? So that one I think is straight.
So for example, I can't go buy a bunch of securities, invest in securities that would not otherwise be Opportunity Zone securities.
You could, but then you're going to have the financial products issue where you have intangible assets that you've owned, and you're going to face the arithmetic tests under the statute and the regulations. With respect to refinancing, we don't have any guidance in the statute or the first regulation package, and we're expecting more regulations by year end. We shall see. But professional consultants, attorneys and accountants have discussed what do we think about refinancing, and there's been a lot of conversations surrounding, well, how do you avoid the mere parking of the tax liability in the opportunity fund and with it coming right out as refinancing proceeds. So one would expect some kind of policing provisions to make sure that the funds have been indeed dedicated to an investment in the Opportunity Zone business. Where that line is going to be drawn, well, we have no idea. You know, can you deleverage the initial construction and then leverage up upon the completion and lease up and take some of the funds off the table? Will that distribution of refinancing proceeds somehow constitute a disposition, quote unquote, of your investment in the fund to some extent? We will await the regulations and be glad to share.
I made a point we probably should keep coming back to our discussions, that all the rules that Liz took us through to start with focus on the fund, that the deferral and the exclusion all assume you are selling or holding the fund, and none of them happen to deal with what happens in the lower tiers that we spent so much time talking about. They don't protect you from current income tax hits or defer anything that happens within your probably pass-through entity.
Although in my world, I'm living in partnership vehicles every day. What happens below is happening up top. It's because everything's pure flow through. So that you do have the statute being very narrow in terms of the disposition of the ownership interest in the fund, but you're still going to be a remote partner in a lower tier partnership, and whatever tax consequence associated with that is going to flow right up. It raises that question, which actually was in the slides, but we didn't have time to cover it, which is what happens if I continue to own my interest in the fund, but there's a disposition of a lower tier property? Right? What's the relief? What's the non-relief? Because I still am a normal K1 receiving partner in a partnership, and Subchapter K hasn't been suspended by virtue of these rules.
See if I could try to, first to let everybody know we've gotten a lot of questions, and we've tried to address them either throughout the presentation or with some of the interjections, and we'll try to do a few more now, and we'll certainly try to follow up with you on responses where we can. If we think we haven't responded to them, but we likely will not be able to get to every question in our time frame. One of the questions, and maybe Robert or Walter would want to weigh in on this, and this relates to the substantial improvement component of all of this. And the question was that they've got a lease where the landlord is responsible for improvements to the property, and they were wondering whether or not they would need to redo that lease so that effectively the Opportunity Zone business would be the one who's responsible for the substantial improvements to get credit for that.
Okay, I'm not sure I fully appreciate the fact pattern. Is it a master lease of a building? I'm trying to figure out the trade or business that's being conducted by the tenant.
Yeah, I'll come at it from the other side, which is if we're trying to satisfy the 90% or more likely the 70% test, the landlord spending the money is not going to count for our numerator of that fraction. So if the landlord spending it, it's not our money, it's not our zone fund money being spent, so it doesn't help us. So that would suggest a reconfiguration being necessary.
But even if you impose it on the tenant, if the tenant is operating a trade or business other than ownership of real estate or master leasing real estate and subleasing it out, its balance sheet likely is going to have something other than real estate on. So you don't wind up with necessarily with a trade or business that's eligible for Opportunity Zone treatment.
I guess I'd play that. If you did have our lower tier partnership, say, actively doing something in a zone, and its lease in the current form put the burden to do tenants improvements on the landlord, but you shifted that over so that lease payments went down, I would think the tenant, if it funded its own tenant improvements, would end up with a balance sheet item that would be Opportunity Zone property that would count for.
Yeah, I say, without having interaction with the person asking the question, why do I want to have that real estate as an Opportunity Zone asset anyway? I'm not selling it. You know, what's the advantage? Seems to me I'd rather have the landlord spending its capital than to create an asset which I'm just going to burn through during my tenancy, as opposed to have something sale value.
Put on your real estate hat.
Yeah.
We did not talk at all. I mean, this program is supposed to also stimulate just operating business. You could throw money in and start up a business and pay rent and employee costs, as opposed to being worried about whether you were funding a real estate venture. So there is a separate world that might go that route, but
okay. To switch gears a little bit, and I think maybe this might be Liz or Walter. One of the questions came up was someone may already have a gain from earlier this year, past the 180 days. Is there any extensions beyond the 180 days?
Well, if the gain is from a partnership and your partnership isn't rolling over, then you have that special rule where you get an extra 180 days at the end of the year. But otherwise, I don't think there's any sort of provision that would allow you to extend if you haven't rolled over yet.
No, there are various comment projects on the proposed regulations. I think some of those are asking the IRS to provide some extension or reasonable cause basis, but as Liz is saying, I'm not aware of anything that's a drop dead deadline absent it being within a partnership that might give you more. So yeah.
And Robert, if you might be able to just summarize briefly again, because we seem to get a lot of questions about it, and maybe some of those have been answered as we've gone along, really, is if someone were to just buy vacant land, how does that really, can you just summarize again how that fits into the program? Does it count? How do you do the substantial improvement of land versus that doesn't have a building on it? Just a couple of those key points.
Yeah, let's say we purchase land from an unrelated taxpayer, and we have a design to make it into an opportunity zone business. The question you're asking, if I distill through it, is how little can I do on the land and still have an opportunity zone?
Someone wanted to know, could I add $1?
Right. As I said, that's why I'm sufficiently perceptive. I can tell how little can I do and still have an opportunity zone business, and it's an unanswered question. We will get regulatory guidance. You have to have a trader business. You can't operate a parking lot. Right? That's not going to work. Right? You have to make improvements, and the question of the scope of the improvements has not been addressed yet in regulatory guidance.
I guess I would go down the math channel also, just that if you've bought this land of itself, it is not necessarily qualified property.
Well, just by location it is.
I guess it is. All right. So
the question is it a trader business?
Yeah. All right. So it's in the first instance, it may end up in your numerator and denominator of these tests. Mm-hmm. Unrelated. Yes. All right. So yeah.
I would think that you could make an argument that a parking lot would be a trader business. I mean, just if you're charging people, that type of thing.
I remember this issue when we had the DC enterprise zones, and we were trying to figure out whether we could, pardon the pun, park our investment as a parking lot, waiting for investment. And we were very concerned back then.
Hmm.
Good. Well, we wish we'd had more time to get to everyone's questions, and we certainly do plan to go back to the questions that arrived here today to see if we could at least be responsive separately to some of those if we feel that we didn't get through them in the materials. Of course, I would encourage anyone listening, you obviously have the contact information of the various panelists, and I think you probably got a sense from the presentation of who does what, and I'm sure they'd be happy to speak with you directly, either by email or phone. Thank you again for attending Venable's webinar.